From Law Society World or International Headquarters in the heart of beautiful downtown and rainy Toronto, welcome to the next 2 hours of a webinar on meeting the needs of clients with disabilities in your law office or law firm. My name is David Lepofsky. I'm a visiting professor at the Osgoode Hall Law School, a retired crown of 33 years, having argued civil, constitutional, and administrative cases for the provincial government. And I'm also chair of the Accessibility for Ontarians with Disabilities Act. I'll be chairing and emceeing this afternoon's program. Let me dive right into it. Three preliminary things you're going to want to know. This program, this program is rated for 2 hours or accredited for 2 hours of professional hours in your CPD requirements, so feel free to chalk them up. Second, this program has been accredited by LawPro for risk management, so you can get a deduction or a decrease or whatever on your insurance premium, so go get a decrease, no idea how much. And finally, a quick thank you to everybody who has sent in questions in advance of the program. All of our participants, our panelists, have read them, and we're going to try to tackle as many of them as we can. During the program, you're also invited to email in questions, and we will, at 2 points in the program, do what we can to take them on as well. So, let me dive right into the content. Our goal today is to help you, whether as a lawyer or paralegal, to ensure that you can meet the needs of clients or witnesses with disabilities who might need to benefit from your legal services or participation in the work of your law firm or law office. We're speaking to lawyers and paralegals. This applies whether you're doing criminal or civil, family, any kind of law, whether you're in a private firm that's big or small, whether you're in a government law office that deals with the public, or with government offices, which include people who you will be working with who have disabilities. Include as well in the agenda of those we can help are people who are in-house counsel in corporations or other kinds of offices. Just two quick things about me if you want to learn more. If you want to learn more about accessibility issues more generally, I unsubtly encourage you to follow me on Twitter. My Twitter handle's @David Lepofsky, my name. And if you want to learn more about the nonpartisan campaign for accessibility in Ontario and in our country, feel free to send an email to the coalition that I chair, the AODA Alliance. Just write aodafeedback@gmail.com, aodafeedback@gmail.com, and all you have to say is sign me up. So, a couple of moments of an introductory overview by me, and then we got two panels. Introductory overview time. There's only a little bit of law you need to know to follow everything we're going to talk about. The law we're going to be talking about, or the topic we're going to talk about, applies to people of with all kinds of disabilities. Physical disabilities that may affect somebody's mobility, sensory disabilities like hearing loss of any degree or vision loss. I myself am totally blind. Intellectual disabilities, learning disabilities, neurological disabilities like autism spectrum disorders, disabilities that you will notice if you're sighted, like a person comes in with a wheelchair, a white cane. Many disabilities that are invisible that you won't know about unless somebody brings them to your attention. How many people are we talking about? Well, we're talking about a lot of people. In Ontario right now, over 1.8 million people now have a disability. Across Canada, it's over 4 million. But that really understates the number of people that we are talking about, because everybody eventually gets a disability at some time in their life, either a temporary one, like a ski accident, or a permanent one. The biggest cause of disability is getting older, and guess what? We're all getting older. The alternative is not an attractive one. So this cuts across a huge swath of people. In whatever area of law practice you're involved in, you are going to be involved with clients or witnesses, or indeed opposing parties, who have disabilities. And this cuts across all areas of law. If you do tort law, you're dealing with people who are injured. They didn't have a disability before the tort, they did after. Dealing with criminal law, disproportionate number of People who are accused of crime and people who allege that they've been victims of crime are people with a physical or a mental health or a learning or a disability or some combination of them. So whichever area of law you're in, this subject matter applies to you. So what is the legal obligation? The legal obligation is something I can summarize very simply. There is a duty on the part of those who offer legal services to the public or to a client population to ensure that people with disabilities can fully enjoy and benefit from those legal services too. There's a duty to ensure that your legal services are fully accessible. Accessibility doesn't just refer to the physical place and the physical barriers that could get in the way of getting into the physical place where services are provided. It refers to all kinds of barriers that can impede a person from enjoying the legal services that you offer. We're going to talk about a wide range of them this afternoon. In order to ensure fully accessible services, those who offer services have a duty to accommodate the needs of clients or others with disabilities, where that accommodation is necessary for them to fully benefit from those services. That duty to accommodate can be found in the Ontario Human Rights Code. It can be found for those of you who are involved with services that the government offers, as well in the Charter of Rights and Freedoms, Section 15, the equality provision. That duty to accommodate is, in a sense, at the core of the Accessibility for Ontarians with Disabilities Act that you'll hear about over the next few minutes, the AODA. That duty to accommodate in connection with legal services is also directly anchored in the professional conduct obligations that the Law Society imposes on all of us who are members of the Law Society. So pick your source, the duty's there. What does it include? It includes a requirement to remove barriers that may now exist and to prevent future ones from ever being created. Is it an unlimited duty? Do you have to do everything right away? And the answer is no. It's subject to a defense of undue hardship. If you need more time to remove a barrier, then you could try to assert that an undue hardship would be imposed to your law office if you had to act more quickly. But the burden of proof to show that accommodation cannot be achieved with without undue hardship is on the law office that says it can't now accommodate. It has the burden of proof, so the presumption is that the accommodation is doable. And for practical purposes, that undue hardship principle really doesn't relate to whether you have to do it, but how long you have to make the adjustments. It's not a question of whether, typically, but when. As part of that duty to accommodate, the Supreme Court of Canada has held that there is within it a procedural duty, a duty to investigate solutions. If you can't find a solution that works right away, you can't just give up. You got to investigate further. So, what do we do about it? Well, before we delve into today's discussion, I just want to let you know that the Law Society has already held a series of 5 webinars over the past 5 years, which I had the privilege of chairing, that focuses on how to effectively accommodate the needs of people with disabilities involved in the court process. And it's a rich series of webinars with a lot of useful and helpful ideas, panels targeted on specific disabilities, whether people with vision loss, hearing loss, learning disabilities, autism spectrum disorder, mental health issues, and so on. Beyond what you hear today in this webinar, I encourage you to check those out. They're available. They're all accredited for CPD professionalism hours. So you can get a lot of benefit from what you learn and get the credit you need. Our aim today is not to explore the outer perimeters of the law in this area, but to give you practical action tips. There's a lot that you may need to do, but we're going to try to give you shortcuts, ways to do it easily, and so on. And each of the speakers on this panel have provided, available to you for download as part of the webinar materials that you got online, I've given you a one-pager with just a short list of things you can do. So, on to the first panel. Our first panel has 3 participants. I'm going to talk to them each separately, and then at the end, within about 45 minutes, we're going to invite you to email in questions if you have any that relate to the first panel. Our first presenter is Jordy is going to speak about the AODA from the perspective of the office that implements and enforces it. Our second panelist, Thea, is a specialist in the accessible design of the built environment, and she's going to talk about what you can do, assuming you're already in an office, you're not building it now from scratch, to try to make sure that your built environment, the physical space, is accessible. And our third presenter, Sam, is an expert in accessible design of documents and of websites, to give you some ideas of what to do to make sure the documents that you produce and the website you provide to the public meet the needs of people with disabilities who are going to want to read them. So let me start with Jordy, just to my immediate left. So Jordy, let me start with, who are you and what do you do?
Well, thanks, David, for inviting me here today. My name is Jordy Gibbon. I'm manager of the Public Education and Partnerships Unit at the Accessibility Directorate of Ontario, which is the department that, as you say, implements and enforces the Accessibility for Ontarians with Disabilities Act.
Okay, now the AODA, for another nanosecond of law here, is a law that was passed in 2005. I have a deep personal connection with it because I led the campaign for its enactment, and my coalition, the AODA Alliance, leads the campaign to get it effectively implemented. It doesn't replace the Charter of Rights or the Human Rights Code. It provides measures to try to get folks to bring themselves into compliance with it. It requires Ontario to become fully accessible by 2025. That's 20 years after the law was passed, less than 8 years from now. It requires the government to lead us to that goal, not by fixing all the barriers in your own law office. Sorry, it's not that easy. But rather by the government enacting a series of regulations called accessibility standards and then effectively enforcing them. Those standards tell organizations what they got to do and when they got to do it by. They don't supersede the Human Rights Code. The AODA makes it clear that the highest accessibility law, the strongest one, always prevails. So you can't just assume that if you comply with an AODA standard, you've done all you got to do under the Human Rights Code. You've always got an eye to your obligations under the strongest of the accessibility laws that are on the books. But with that, tell us about the accessibility standards that are out there and that may apply to a law firm delivering legal services to the public.
Sure. So there's 5 accessibility standards in the province right now. And these accessibility standards are meant to set a minimum level of accessibility across the province. So I'll be speaking about the minimum legal requirements you have to meet. And I'm always really happy to speak on a panel like this because we've got some really great experts that can talk about going beyond the minimum requirements of the law. So the audience today is probably going to be most concerned with the customer service standard, the information and communication standard, and the employment standard. And the Design of Public Spaces standard also has some requirements around service areas that might impact your law office. Now, the exact requirements that are going to apply to you depend on how large your organization is. But if you are an organization operating in Ontario and you have employees, you do have some requirements to meet. The larger organizations in Ontario, for example, if you have 20 or more employees or 50 more employees, have more requirements to meet. For example, if you have 20 or more employees, you're required to file an accessibility compliance report with the Government of Ontario by December 31st of this year. And that's part of how we track compliance. So if you want a handy checklist.
And that's filed online, right?
That's correct. Yeah, I can guide you to those resources in a moment. But if you want a handy checklist of everything you need to do, an organization of your specific size, you can navigate using the one-pager I provided to ontario.ca/accessibility. Now, what you're going to come to is quite a list of various requirements, but it doesn't really matter what size of organization you are. Probably the first thing is make customer service accessible, and that's a lot of what you've been talking about, David. And I think it's a really great place to start. If you haven't done anything, you're probably going to look at the list and think to yourself, well, we've got a lot to do. But I think it's a really great place to start because it starts the conversation about accessibility in your office and gets people asking questions if they're really ready to provide for the needs of people with disabilities if the eventuality comes up. So for me, a great first step is to train your employees on accessible customer service. I like this first step because within the regulation, there's a number of areas that you need to cover within the training. One of those areas...
So the regulation itself imposes training obligations.
That's right.
And you folks at the Directorate put out resources if people want to use them, like ready-to-go training tools, right?
Absolutely. And the training tools will cover all these areas. But if you just use those training tools, I don't think you're really taking advantage of the opportunity to discuss inclusion at your organization. For example, the standard says you need to train staff on equipment and devices available on your premises that will help remove barriers and help provide goods and services to people with disabilities. This is a great opportunity to stop and discuss and think about whether your premises is accessible, identify any potential barriers, and then incorporate that into the training. It also requires you to include content that relates to how to communicate with various people with various types of disabilities. And this is also a really great opportunity to start a conversation about whether you're prepared to provide accessible customer service. I think a lot of the time people have great intentions, but they're not necessarily aware of how to interact appropriately. They don't want to say the wrong thing or do something awkward, and it's a great chance to have those conversations and ensure everybody's comfortable and ready to provide their services in an inclusive way.
So important 2 points about the training, one of which is if you use the government's resources, there's no charge. They're off the shelf, they're ready to go. And if you're a smaller office and you don't have time to look at more extensive training, they're good to go just to grab them and use them. And the second thing is what you find out is that this is a regulatory requirement, but it's also something that would be good for your organization to do, even if it wasn't a regulatory requirement. It's good for your operations. Sorry, so carry on, beyond the training.
Beyond the training, there's some other areas of customer service you have to look at. For example, you need to establish an accessible customer service policy and have accessible feedback processes. So if it does happen that somebody runs into a barrier to your goods and services, they can provide that feedback to you and you can react to it.
Now, when you talk about a customer service policy, there's the accessibility director has a template if there's one you want to just borrow and use as is, right?
Absolutely. You can find that template by navigating through our website, and the checklist will navigate you to it. But again, it is sort of a baseline template, and I encourage you to use that opportunity to really have a good discussion about inclusion at your organization.
So if the law office, public or private sector, takes that template, then they could have a discussion internally on what they might want to do to modify it to fit their specific needs.
Absolutely.
And the advantage of this, speaking as an individual with a disability, is if you go to an organization and you want to know what's available, if they've already got a policy on it, that can be a good first step. And while the regulations don't require you to post them on your website, a number of organizations commendably do. And I track these on the internet, excuse me, and it's actually helpful. And it's frankly it's actually good for an organization to be able to publicly indicate its openness to ensure that these needs are met.
Absolutely. And if you're wondering what the link is to the free training modules on all the accessibility standards, including customer service, it's accessforward.ca. And again, you can find that link in our one-pager.
All right. So and talk to me about what's customer feedback all about? I mean, for one thing, lawyers and paralegals might not think about customers. They may think about clients. But what's the feedback thing for?
Essentially, organizations are meant to react to their own feedback. The government of Ontario does accept feedback about AODA and the implementation of the law, but we don't really react to specific complaints against specific organizations. The law is designed so that organizations can accept and react to that feedback themselves. So
if this relates to, for example, if somebody's encountering a difficulty or a barrier in your services, feedback is the way for the public or your clients or others you deal with to report to you and for your organization to track how you're doing, whether you're doing well or doing poorly, and then intervene to figure out ways to fix it. So that's the customer service policy regulation. What about the other ones?
I think another important area to look at is the information and communication standard. And here's a standard that's designed to help organizations make their information accessible to people with disabilities. Essentially, you need to make information that's available to the public accessible in an alternate format upon request. So I think the big thing to consider here is whether your organization is prepared to provide information in an alternate format. And this could mean anything from a properly formatted digital file that can interact with screen reader software, or it could even mean a document in a large size font. The idea here is that you interact with the person making the request to determine the format that's most useful to them and that's best for the organization, and to provide it in a timely manner so that they can access the information that everyone else can get to.
And a helpful thought for folks to understand, they might be scratching their head going, well, what equipment do I need? Well, for most alternative formats other than Braille, and Braille is not used by a huge number of people, but for most accessible format needs, you already have the equipment in your own law office, on your own computer, laptop, desktop, or even probably tablet that you would need to ensure accessible formats. We're going to have a discussion about accessible document format in just a few minutes with our third speaker on this panel. So that's the information communication.
And also under the information communication standard are the web requirements, which do require large organizations of 50 employees or more to make new and refreshed websites accessible, as also public sector organizations. So I think I'm going to let Sam talk about that in detail, but do understand there are requirements in place right now for large organizations to make new and refreshed websites and web content accessible to people with disabilities.
And for those watching who probably are hearing for the first time, web accessibility is like a very important topic. And as long as you build accessibility in when you're creating the web content, you can solve the problem before it happens. It's not a hard thing to do. And for those organizations or law firms that might be smaller than the 50 employees line, while the AODA standards don't apply to you, the Human Rights Code does. At least I would argue, and the Federal Court of Appeal in relation to the federal government held that the duty to accommodate includes a duty to have accessible websites. So whether or not the AODA standard covers all organizations, I think it's wise to proceed on the basis that that your websites do have a requirement of accessibility. More on how to do that in a couple of minutes. Carrying on?
Sure. And then I think the other standard that's really important to talk about is the employment standard, which is essentially requirements to help organizations incorporate accessibility into their human resources processes to make hiring and workplace more inclusive to people with disabilities.
So if somebody is watching this and they want to learn more about what they've got to do and they want to get other resources to help them out, what will they find on the government's website?
You're going to find lists of plain language requirements that you need to meet, as well as the links to the regulation, as well as links to really helpful compliance assistance resources, such as templates, as you mentioned, training modules and videos that are going to help you understand what you need to do. You'll also find specific examples and scenarios that'll help illustrate the need for compliance and how you can meet the standards.
Now, one question that we got from a number of people watching this, anticipating watching this, is if I've got to make changes that cost money, whether to my physical environment or otherwise, is there any sources of funding that I might find outside my own organization? What can you tell us about that?
So the Directorate doesn't provide any funding to comply with the standards. If you're talking about making physical changes to your building, there's also, not really any requirements under the AODA to do that. Those are still held in Ontario's Building Code.
And the Human Rights Code.
And the Human Rights Code. But there is a fund that's run by the federal government called the Enabling Accessibility Fund that does provide financial assistance to improve physical accessibility and safety for people with disabilities through, supporting capital costs. So that's the Enabling Accessibility Fund. It's run by the federal government, and you might look there for funding.
And finally, we've been talking about these requirements in terms of what the actual requirement is. The Act also has enforcement powers. Can you just tell us briefly about the powers of enforcement that the provincial government has?
That's right. So the provincial government does enforce the Act. We try to use a public education focused approach as well as the stick. but there are organizations that have paid financial penalties for not complying with the Ontario's accessibility standards. We do audit organizations on a regular basis to ensure compliance with the standards. And one of the most important things to ensure compliance that we do is ask organizations to file those accessibility compliance reports. That again, if you're a large organization with 20 or more employees or a public sector organization, you do need to file that by December 31st, 2017 and certify that you are compliant with your requirements.
All right, thank you very much. Stay put because we'll be getting questions soon, but let me turn next to Thea. We've gotten an overview, Thea, about the AODA requirements. Tell us who you are and what you do.
Thank you very much, David. It's a pleasure to be here. Thanks for inviting me. My name is Thea Curdy. I work at Designable Environments, and I'm an accessibility code specialist and universal design specialist. So we're looking at buildings both for people with disabilities and for people from the age of 5 to 95.
So why would somebody, when somebody comes to your organization for help on accessible building design, why? What do you guys do? Do you design the building for them, or what do you do?
Yeah, well, there's several things that we do. We can work with, if you are going to be moving into a new office, we can work with the architects to make sure that that new space is accessible. We also work with existing buildings, so if you already are in an office, we can come out and do a building audit and tell you what the status of your office is for accessibility and meeting the needs of a diverse range of needs for people. And then we also write accessibility standards for every level of government.
So when you assess, you do also give recommendations of what they can change.
Absolutely, and we don't just focus on the minimum. Because we're cognizant of that people have to meet the Ontario Human Rights Code, we're often able to provide much better information for people, having written accessibility standards that look at the actual needs of people with disabilities. And yeah, it's a process of A, recommendations, B, identification, and C, we also focus on priorities. So we can help people figure out what are the big barriers that they have, what are the issues that are good to fix items, and what are the issues that it would be good if you could get to them. Often there's a cost associated with the really important barriers that you have, but the good news is that what we would call the priority 3 are often easy to do, inexpensive things that actually cumulatively make a huge difference for accessibility.
Okay, well, we're going to talk this afternoon from the perspective of somebody watching this program, Thea, who's not building a new office. They're already in one. They probably are renting it, and they are listening going, oh my God, I don't know how we are. Maybe we're really bad. And before we jump into what should they look for and what can they do, I want you to first tell us what disabilities are you looking for when you're looking at the built environment? So people watching this are figuring, yeah, people in wheelchairs who can't go upstairs, that's it, right? Tell us, what other disabilities may encounter barriers in the built environment?
Well, that's exactly it. When people think about disability, they tend to think about a person in a wheelchair. And of course, if you think about a lifetime of changing needs and abilities that we all have, then of course, even if we think about older people in our own lives, we could be thinking about, right off the bat, vision loss, hearing loss, arthritis. But then if you looked at the whole functional range that people have for abilities and the cognitive range that people have for disabilities, and I really prefer to focus on the ability part because it's just a changing set of abilities. So whether that's even fatigue and stamina issues, there's a bunch of things that you can do that actually, or conditions people have that could be, up to 70% of people who would be classified as people with disabilities. You can't tell from just looking at them. There's nothing like a walker or a white cane or a wheelchair for them to be identified with. So it really is about trying to meet a diverse range of needs.
So built environment barriers can touch on a wide range of disabilities, well beyond wheelchairs. So give us an idea of some of the things you would look for or encourage people watching today to look for in their own organizations as being priority areas for looking for built environment barriers. And give us ideas of the kinds of things that might be done at a low cost quickly in some cases, and at more cost maybe takes longer to fix them.
Well, picking up on what we were just talking about with the AODA employment standard has actually introduced a new element to this conversation. Traditionally, when we've talked about accessibility, people have focused on what we would call the public or client side of the practice. And the AODA employment standard, where we're hiring people with disabilities now, it's really expanding that to thinking about just everybody in the office space could be people with disabilities, and likely will be as we age.
And that doesn't just mean who you go out and hire tomorrow. It could include you, yourself, if you get a disability, which you likely will, later on, or some of your colleagues at work, and then suddenly find out that they've got barriers in the workplace they used to be able to navigate with no problem.
Yeah, so the tip sheet that we put together for this program covers 4 different areas for you to be considering. And we tried to give you some quick resources or ideas about what you might be looking for in those 4 areas. So the first area is looking at the actual entrance into your office space. We provided also a quick diagram, which was great about things that you might consider or think about on the outside of the building. But those things are generally outside of your control. So we were trying to focus on what was in your control. So the office entrance was one of them. The interior path of travel, that's just your corridors and how you get around inside your office. Of course, your reception area, how people are greeted and the first impressions they have of your office space. And then, of course, the other spaces that you might have, including your offices, your meeting rooms, your photocopy rooms, and even kitchens, which is something traditionally hasn't been something people have thought about for accessibility.
And let's not forget washrooms.
Of course. Now, one of the things with washrooms is it very much depends on your facilities, whether the washrooms are actually a part of your unit or a part of what we would call the base building outside of your unit, maybe a part of the elevator core. So depending on where those washrooms are, you may have control over them. That may be something you need to negotiate with your landlord.
So while you going in and doing an audit of an organization, you would go through these areas and examine them. Give us just some examples of things that a law office could do right now, even on their own, to improve things in these areas as possibly temporary fixes, but rapid action.
Absolutely. Well, one of the best things people can do is paint. Color contrast is enormously helpful for people with vision loss and people with cognitive impairments.
Color contrast, we're talking about people with low vision, which I used to be, and where things are all the same color, you can't tell such things as what?
So, for example, if you provide some color contrast around the door frame, so the door frame itself contrasts from the wall, the desks from the floor. These are really simple things that you can add some quick color to. You can add some color around the hardware around your door so that the hardware stands out from the door itself. And then thinking about people with hearing loss, you don't have to get into a big rewiring job to put in a hearing assistive listening system. At your reception desks, there are portable hearing loop systems. And hearing loop is something that is well tested. It's been 20 years on the market in Europe. And you can put up a little sign. And what the magic of this is that your receptionist can speak into a microphone, and the person with the hearing aid gets that audio information directly into their hearing aid. So that's an important piece that often is overlooked. And again, it's one of those off-the-shelf products you can buy, place in your office, and have be ready to go for tomorrow. Okay,
path of travel. Talk about things that might be easy to do.
Okay, so path of travel. One of the things that we have to think about from a space concern is if you were using an assistive device, is there enough room for you to navigate around the office? So the Ontario Building Code, for example, requires you to have just shy of 4 feet of clear space to navigate from your front door to each of the areas that you would be traveling to within your office.
That's in a new building, right?
So traditionally, again, the Ontario Building Code looks at anything that's newly built or if it's having significant renovations. One of the things that we're also looking at because of the Ontario Human Rights Code is covering off people's liability issues for the duty to accommodate people. So trying to provide that path of travel is just, in many cases, reorganizing your furniture, rearranging where things are placed, making sure plants are out of the way. It's about almost sitting down with your floor plan of your office and just taking a pen and drawing a line from the front entrance to each of these spaces that gets you a really good start to thinking about where this might need to happen.
So if you're thinking that all these barriers require you to do major structural changes, sometimes just some rearranging some furniture or getting that planter out of the path of travel, or what I love to find, the garbage cans sitting in the ramp blocking access to it can make a huge difference. I want to just, in the last few minutes that we've got, Thea, and we're going to be open to questions, I want to just highlight a couple of things. One is that Thea has mentioned, she's mentioned the building code a few times. A problem is that we've got a couple of problems. One is the building code's accessibility requirements are woefully inadequate. You can build strictly a new building to the building code and yet create lots of accessibility problems. And if you want an example of that, I encourage you to just go to YouTube, search on AODA in Centennial College, and you'll see a video that I and my coalition created, which has gotten a lot of attention in the media and among design professionals. A brand new building built at Centennial College, and yet it's got significant accessibility problems, even though they clearly applied their mind to accessibility, wanted to do the right thing, but were guided by a law that's way too inadequate. The Human Rights Code is the standard that applies. Even though the building code applies to new builds or renovations, major renovations, an organization that provides service to the public can have a duty to address retrofits under the Human Rights Code, and there have been liability findings under the Human Rights Code. You should be aware of that. The last thing I want to mention is that built environment, and Thea, maybe you can talk to this, changes to your built environment that help people with disabilities with accessibility pretty much universally help everybody. Anybody going to the front door of Osgoode Hall to go to court here at the building we're in Toronto, now that they put a ramp up to the front door, will remember happily how good it is to walk up there with a bag on wheels rather than tripping over cobblestone and trying to drag your bags up steps. Can you just talk to that, Thea, for a minute about how the changes that would be needed to the built environment help everybody, not just people with disabilities?
Absolutely. This is actually sometimes referred to as the curb cut effect. The curb cut was originally put in to try to address the needs of traveling around the environment for people who are using assistive devices such as wheelchairs. But then they actually found that people who are using strollers or people who are using carts or just people who were unable to lift their feet clear of the ground, perhaps as you're aging, that this is a benefit to everyone. So a lot of these things, adjusting your furniture, adjusting your kitchens, one of the things a lot of people aren't aware of is that the building code is actually designed for a 6-foot-tall person, which means that the counter height that is specified in the building code that we are so accustomed to is actually not ergonomically perfect for women, generally, who are not in that height range. In fact, the average Canadian woman is about 5'4". So lowering the counter height to what we would call the accessible counter height is actually a better ergonomic fit for a larger percentage of our population. There are also things that we do for signage. Signage is a huge opportunity to make a big change in your office spaces, and providing things like words to explain what the place is, and the braille that actually says what the words say, so that's consistent.
Okay, I got to jump in on this one because one of the ones that I find frustrating, the U.S. is way ahead of us on this in so many areas, and one of them is in public washrooms just having braille in large print on the bathroom signs. So when I'm in the States in a public building as a blind individual, I can know with confidence that I'm walking into the right washroom and not going to be embarrassed. In Canada, way, way less so. We're not talking about a big cost to put up a raised letters and braille sign on the bathroom doors, but it's a real help to a whole lot of people.
Right, so other things to do with signage is the provision of symbols, or using these pictograms that show, for example, in a washroom, a man or a woman, help people who don't have the language skills, people who are illiterate, or people who don't speak English. So it's multiplying and adapting. It's really about creating adaptive spaces and inclusive spaces that really accommodate a wider range of users.
Okay, I'm going to thank you, Thea. I'm going to also just let folks know that there are design professionals with expertise in accessibility, of which Thea and her firm are one. But do not assume that just because someone has a degree and a license to practice in architecture, that they know how to design a building to be accessible. In fact, from those perspective of those of us like me and my coalition who advocate on accessibility, we find that quite often they don't. And in fact, they labor under the misapprehension too often that all they got to do is meet the inadequate building code accessibility requirements. And so you might think, oh, they're an architect, they know what to do, they'll do it right. On accessibility, it's really important to talk to accessible design consultants who actually know accessibility. It's not unusual in major projects, and it should be universal in major projects, that accessibility experts have to be brought in to guide the architects, not to create problems, because otherwise, sadly, they do. The example of the Centennial College Culinary Arts Center that's on that YouTube video I mentioned is just one. Thank you very much, Thea. I'm going to now turn to our third and final panelist, way down at the other end there. Sam, tell us who you are and what do you do?
Thank you, David, for the opportunity. I am Sam. My full name is Sambhavi Chandrasekhar. I'm Accessibility Program Manager at D2L, which is a Canadian educational technology company. I'm also adjunct professor at OCAD University, and I teach and supervise research in their master's program in inclusive design. And I have been involved in projects relating to disabilities and technology for about 10 or 11 years now.
So the people watching this, they get, when I was talking with Thea about buildings and accessibility, so they've learned that it applies to people, not just people in wheelchairs, but they always knew there was some issue about at least accessibility in buildings and people in wheelchairs. You and I are going to talk about accessible websites and accessible electronic documents. They don't know the first thing about this, I think, in a number of cases. So what makes a website accessible or not? We'll talk about websites and then documents. What makes a website or web page accessible, and what makes it inaccessible, and what kinds of disabilities are we talking about here?
Okay, David. So segueing from what Thea was talking about, the built environment accessibility, there's good news and there's bad news when it comes to digital or web accessibility. The good news is that it's way easier to make a website accessible than to make a building accessible. The bad news is that you got to keep doing it repeatedly. In a building, you just build it once properly and then it's done. With websites and documents, you got to keep at it all the time.
Because as you add new what you mean is you add new content.
Yes, every time you add a page, if you don't put descriptive text for an image, what was accessible yesterday becomes inaccessible today.
So let me give a sense just to assist here. As a blind individual, you might figure, how's this guy reading a website? So I have a computer, as do lots of us people with vision loss, that has a voice on it, a screen reading program that reads what's on the web. If the web page is designed properly, if it's coded properly by your web designer, then my computer will read it. My iPhone will read it. If it's designed without the proper code, you can read it visually, but all I hear are words like image, image, link, link. I have no idea what's there. So it can make a huge difference, or button. So what do we do so that a blind person, dyslexic person, or others people with color blindness don't experience image, image, link, button when they try to read a page?
Okay, you're so right, David. But technology is the problem, and technology is the solution as well. The one important thing that we need to understand, first answering the question that you asked earlier, is what are the disabilities that impact web accessibility? So obviously it's not mobility, but we do have another physical disability called dexterity, which is how well can you hold the mouse and move it around and click. So you cannot click a mouse if you cannot see where the target is. You cannot click a mouse if you are not able to hold it, like if you have Alzheimer's. So that's one capability we need. And then, of course, we need to be able to see what's there on the screen. And like David rightly explained, people who cannot see generally have a tool which converts text into audio.
By the way, the equivalent, you've probably heard about people who try to spend a day in a wheelchair. What we challenge people to do is try to spend a day on a web without using a mouse.
Yes.
And see which websites make sure you can do everything from the keyboard and don't require a mouse, and which websites have key buttons like Buy Now that are only available with a mouse.
So the problem with technology is that people could be constrained if they cannot see, if they cannot hear, if they cannot use the mouse. But the solution that technology offers is that it can be multimodal. So you can present the same information in visual form, and rather than audio, I would say in text form, so that it can be converted into audio for people who cannot see. And then you can also make it possible that people can use only the keyboard and not the mouse. That way you can get over the dexterity problem. The other very important thing that I want to stress, and it connects with when I said you got to keep doing it again and again, I would say we have to look at web accessibility as a process and not as a goal, not as something we need to do and get done with on a particular day, but we need to have a process in place. Like if Office documents accessibility, if you have a template made that's accessible, then any number of Office documents you make, it'll be 80% easier to make them accessible.
Okay, now, the good news in this area is that there are detailed standards on what an accessible website has to meet. And they're international standards, and they're international standards that the Ontario government has adopted into law for Ontario-based organizations. Tell us about the Web Content Accessibility Guidelines.
Okay, the WCAG is...
WCAG, so we got to pronounce it as WCAG.
That's a name that sends tremors down the back of people generally, but I wouldn't say you need to be scared, because it's all about perceivable, operable, and understandable. You need to make your websites perceivable, you need to make them operable, and you need to make them understandable. And if you look at it, perceivable has everything to do with sight, right? So when you put images, if you're making something visual, you need to make sure that you have text alternatives so that people who cannot actually see the screen can know what the text images are.
And let me just explain. This means two things. You got a picture, then you just have words and a caption below that say what the picture is. If you've got a button with an image on it, then you tag it. Your web designer tags it with words so that our screen reader won't just say button, it'll read the words. So a sighted person will see an image of the button that may mean buy now, but we'll hear the words buy now.
The other thing about if you're low vision, then color contrast should be acceptable. There are certain ratios prescribed by WCAG, so you need to make sure that the color contrast on your website, whatever it be, whether it's a video you're putting up, an image, or text and background, needs to conform to standards. As well, you shouldn't use color alone to convey information. Some people might be colorblind. If you say all errors are indicated in red, no, put a star as well. So these are things that pertain to perception. Okay, you perceive things on the website or web page. Next, what do? You operate on it. You find a button, so you click it. Here's where dexterity comes in. Imagine if your clients are not able to click the mouse, they should be able to use just the keyboard. So a very, very important point, in fact, the second most important after alternative text for images, is that every control should be operable using keyboard. It's not difficult for the engineers to code it that way. It's very easy. If they do it properly, you can actually work on a web page without using the mouse quite
and
easily.
From all those of you watching who get a repetitive strain injury from clicking a mouse too much and too often and too quickly, you will find being able to do this from a keyboard to be actually quicker and better. You can give people both options, the mouse option and the keyboard option, but it's important to have both.
And then the third is, okay, you have clicked, you read somewhere, you're reading something, or you're trying to fill a form, you should be able to understand. So that's the way perceivable, operable, understandable operate. So if to understand, the language needs to be simple. And I think Jody was talking about simple language guidelines
Plain language,
as
right.
well. So besides making it simple, we also need to remember that people who use a screen reader in the normal course, if there's no other design, good design, the screen reader would start reading from the top left and go on till the bottom right of the web page continuously, line by line. But that's a bad thing because they wouldn't be able to look at it and in a shot, they wouldn't be able to see what's important. Like we are able to browse, right? So the good way of designing is to have headings of different levels, heading 1, heading 2, heading 3, and to include that in the code as a style so that they can jump from heading to heading to heading. Or
I'm just going to explain how it works. If somebody like me is using my computer with a screen reader and I go to a web page, if I type, while it's reading to me, if I hit the letter H, it jumps down to the next heading. It just if it's properly coded.
So if we just make it bold and make it 16 point, it doesn't become heading 1. Visually, it might be different, but you have to actually code it, and these are not difficult.
Okay,
Again,
I'm going to, just because we're going to run out of time, and I want to get to documents in a minute, Sam, I'm going to gamble that the folks watching this, many of them may think, oh, I never heard about this. Sure, I'd love to do this. I don't do my website. How do I get it done? Now, can we assume that just because a law office hires a web geek to do their website, that they know how to do accessible web page design?
Unfortunately, David, there is no course or degree that confirms that a certain person is able to do web audit or web design well. It's more of a craft now than engineering. So we need to go by track record. We need to find out.
The thing that I recommend, just so you know, there are a number of web specialists who do know how to do a web page and know how to do it accessibly. Pardon me, what is important for you to do is when you're retaining someone to do your web design or hiring them for your firm, whether they're an outside consultant or there's someone you're going to hire to work as an employee, to put in the hiring criteria that they have to know accessible design. And if you're hiring an outside company to just do all your web work, if you're a smaller firm or whatever, you want to put in the agreement with them that not only they will do accessible design, but if they create any accessibility problems, that they'll remediate it. You shouldn't have to pay them to fix their own mistakes. But it's important for a law office of any sort to make sure that the people who design their web page, web content is accessible, that they know what they're doing. Now, there's two pieces of good news in this. One is your archived past web content from 10 years ago is not going to be important. It's really what you create principally on a go-forward basis. If it's an interesting newsletter you put up 15 years ago, if somebody needs an accessible format, they can ask for it. You can do something about it. But for what you should focus on starting tomorrow is on what you do with your new content. The other piece of good news is it's usually thought that big organizations can achieve accessibility quicker than smaller firms. On web design, it's actually the opposite. If it's a small firm with a small web page, you can get a consultant to fix it relatively quickly. You may not have that much web content to fix. Now, I want to just take 1 minute with you because we're going to run out of time to talk about documents. While law firms will hire web specialists to create web pages for them, lawyers, paralegals, and their secretaries and assistants and students are all creating electronic documents. What should they know? Give us a couple of quick do's and don'ts to make them accessible.
Yeah, so fundamentally, 80% of our work would be Word documents, so I'll focus on Word, although there is resources for every other type of document as well. So in Word, practically it would be the same consideration that you do have for websites, web pages, not very different, but if you're adding an image, please make sure it's in line with text and not floating around, because you would actually add the alt text, but if the image is floating around, then it'll read the alt text somewhere else. instead of where it should. So that's something slightly different from web page. Other than that, you need to have alt text. These days, it's very easy if you have the latest version or one of the more recent versions of Word. There is a tool that checks accessibility.
It's a tool that's part of the most recent version of Microsoft Word.
And then it tells you what the errors are. And one of the most important that we need to watch out is do not add carriage returns to add lines. David would know it'll say paragraph, 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 paragraph. Or if you add spaces, it'll say blank, blank, blank. Have you ever had that experience, David?
Yep.
So usually they tolerate it, but why should they? You should add, using the paragraph option, you should add how many points you need spacing. It's not difficult. If you get used to it, it gets very easy. So these are, and again, tables. Imagine a row and column of values. You need to indicate it's a table, and you need to say what the header row is. Every row heading, every column heading, you need to specify. Then after that, when the screen reader reads it row by row by row, they know what the values correspond to.
Now, Sam, you've provided a tip sheet as well that'll give people links to resources on all of this that they can share with their web designer and with the staff in the firm on accessible document creation. Let me just add one more thing for you all in terms of documents. The three nastiest, ugliest, most hated letters from the perspective of those of us who are blind when it comes to this topic are PDF. When you create a document, if you just open Word and type a document, it is starting from the very get-go fully accessible. It's fully, you don't have to do anything. It's great if you mark up headings and stuff, but we can read it. You send it to me on an attachment, I can open it, my computer can read it, my iPhone can read it. I don't need anybody who's sighted to read it to me. When you convert it to a PDF, you are immediately stripping it of accessibility. Now, Adobe will claim there are things you can do to battle your way back to make it accessible, but you got to spend a lot of time, and it doesn't always work, and it doesn't always get you right back to where you started. What's the solution? If you're sharing a document in PDF, also make it available in MS Word. If you're pasting it on your website, post it in PDF if you feel like you must, but also in Word. For those of you who've been told, oh, we've got to use PDFs because otherwise people might alter them, it's kind of a phony chain of reasoning you've heard. Because number one, there's always a way to doctor a PDF. And number two, as long as you've always got the original document, you can always prove if somebody's doctored a document, whether it's a Word or a PDF or a piece of paper or whatever it may be. So PDF is not a guarantee against doctoring. But in any event, if you look at a good website where they do use PDFs, they also make documents available in an alternative accessible format. That's really important. All right, now I'm going to take a moment. Thank you, Sam. I'm going to take just a couple of minutes to see if we've got any questions that have come in by email. Jordy has the iPad. You got anything there to field to the panel?
Yeah, there's some interesting questions that have come in.
Give us a couple if you don't mind, and we'll divvy them up.
Absolutely. So one of the good ones I thought that came in, a lot of people are using do-it-yourself website tools such as Wix and GoDaddy. Are there any accessibility tips for using these do-it-yourself tools?
I would say WordPress would be a good example of a do-it-yourself. And there are accessible templates available in WordPress. So if you use those templates, you're safe. More or less, you can make sure. And then one important point I want to slip in, please have your web pages read by a screen reader user and pay them. Pay them like you would pay anybody else.
You mean to check them?
To check. Because that word will carry through the community that you care, and 80% of your errors will be spotted.
And by the way, there are automated web checkers, but I'm told they render a lot of false negatives. And
that would be the first level. You do an automated check, and then a manual check, and then you bring in somebody. It's more about the user experience as well when you bring in a screen reader user.
What about the other tools that came in on the question, GoDaddy and the other one?
Oh, yeah. GoDaddy would be a hosting site. WordPress would be a typical Wix WordPress. These are typically allowing you to make your own website by just putting in a few of your own words. Like I said, if you use an accessible template, that would be a good way. And then when you are actually, they don't expect you to do the HTML part, but if you have to make if you're putting in an image, you would have to go into the HTML and make the alternative text, because the alternative text doesn't depend upon what picture it is. It depends upon what the context is. It has to be meaningful to the context. So you may have to do some of those tricks in the HTML, but most of it will be taken care of by the template.
Okay, Jordy, other questions?
Yeah, it looks like we've got some people who are trying to make decisions about purchasing office furniture, such as pedestal tables. Any tips on types of furniture to buy that are particularly accessible?
Yeah, this is a really good question. There's actually a lot you can do around furniture. In fact, that's one of the things that we often recommend to clients, is that they do what we call a furniture, fixture, and equipment review. Even things like photocopiers can be more accessible, and asking the suppliers for that you want to have accessible features, or getting some advice from a professional will be useful in this area. But pedestal tables are problematic just from the very beginning. We advise nobody use them. They, although they provide seemingly more space around, unfortunately, because of the way the pedestals often work, that they actually block access to the table. So someone who's using an assisted device like a wheelchair, unfortunately, the small wheels at the front of that assisted device can't actually get fully under the table because it's blocked by the pedestal itself. So that's something to certainly watch for. Reception desks would be the other place to look for accessible features. And again, you're not looking for something that's going to put somebody off to the side for accessible service. You want it to be up front, middle, center, as a way to show equality.
By the way, if you want to learn more than is provided in the tip sheets that we've provided, Twitter is actually a great resource. And I'm not just plugging my own Twitter feed, which I happen to mention was at David Lepofsky, shamelessly. But if you search on the hashtag #accessibility, or another one that's commonly used, which is # and then A11Y, you'll find lots of links to new resources, webinars on accessible web design, document creation, WordPress, furniture, all sorts of stuff from right around the world. There's a ton of good resources. Maybe we have time for one more question.
Sure. There's a lot of questions about quick solutions to physical accessibility barriers in offices.
Okay, so Thea, let me ask you about a couple, one of which is temporary ramps. One thing that people worry about is having a couple of steps at the front door, and they figure, oh my God, I've got to go spend a whole lot of money putting in a permanent ramp. One opportunity that's available is buying or having built a temporary ramp that might be available, either you situate it out there as needed or whatever. Can you just talk a little bit about that?
Yeah, so if you have a situation that you just recently become aware of that you now need to get solved, certainly a temporary small ramp, for example, Stopgap has an organization that makes ramps for people, and they're brightly colored so that they stand out and people can find them, and that's terrific. But if you're aware that you have an issue with stairs, that's probably going to be a longer-term problem. And the great thing is that you can look for a short-term solution with a temporary ramp and then spend the time and have the resources put aside to address that in a more comprehensive way longer term.
One of the questions, just building on this, that we got before we started from a couple of you is, I work out of a home office. I don't see clients in the home office. I arrange meeting space elsewhere. What should I look for? Thea, can I just pitch that one to you?
Yeah, absolutely. So the same types of things that you're thinking about for your own office space are things that you're asking for on the phone when you're trying to book these spaces. Identify that you want to have an accessible office space, that you need to have an accessible entrance. You're looking for accessible parking. The accessible washrooms are an important part of this. Often, the more we ask for it, the more people become aware that this is something that's needed on the marketplace. And I've often found that as I'm asking for other clients, or even for myself as we're looking for a new office space, that the people I'm talking to are very helpful at getting us access to other people who might be able to help us.
And just so you know, I mean, as a short-term solution, if your office has no physically accessible place to meet with clients, you can look up and research and see if there's an alternative place that you can rent on a short-term basis or an as-needed basis. That's if you've got your own office already, or if you're working out of a home office. And of course, part of your long-term planning should be looking, if you're going to be looking to move anyway, or considering whether or not you should move, you should consider in the mix whether a move could bring you to an accessible venue and take you away from an inaccessible one. I'm going to thank this panel very much. I'm going to invite you to go sit in the cheap seats here while we bring up our next three presenters.
Thank you, David.
Thank you.
So, just as our new set of colleagues are coming up, let me just explain what we're going to do for the next few minutes, next little while, and for the second half of the program. We want to now talk about going beyond the recurring barriers that are in the built environment or in the digital environment to talk about a broader range of kind of barriers that clients with disabilities might experience. And we have three presenters who are going to, in a lively discussion, give us some illustrations of the kinds of barriers that have been experienced and some ideas of how to fix them. So with me, let's go across the panel. I'm going to have you first just tell us in a nutshell who you are, what you do, and what exposure you've had to clients with disabilities. Starting to my immediate left is Rob Latanzio. Rob, who are you?
Thanks, David. I am Robert Latanzio. I am the Executive Director of Arch Disability Law Center, and we are a specialty legal clinic located here in Toronto, but we have a provincial mandate, and our focus is to advance the rights of persons with disabilities.
And so your client population is all people with disabilities.
That's correct. And I should mention that we are a cross-disability organization. We're primarily funded by Legal Aid Ontario, and we do take on cases across the spectrum in terms of disability.
All right. Next to Rob is Joanne. Joanne, who are you, and what clients with disabilities has your organization served?
Thanks, David, and thank you for inviting myself from Ottawa. I'm Joanne Solkauskas, and I'm the Executive Director of REACH, which is a local nonprofit charitable organization based in Ottawa, established in 1981 during the International Year for Persons with Disabilities. And REACH has a twofold mandate, which we continue to practice 36 years later. We provide education and information to the community on matters pertaining to persons with disabilities, their rights, interests, and resources, and as well, and pertinent to the discussion today, we provide legal referral services at no cost through a panel of today 160 lawyers in the Ottawa community who provide pro bono services for people with all disabilities and their family members. And I've been doing this for 2 years, and I'm just very proud to represent the agency, which was established by lawyers in Ottawa and a person with physical disabilities who 36 years ago decided there need to be more available, accessible services for justice.
So the first two organizations we're hearing from both serve the broad spectrum of people with of all kinds of disabilities. Finally, we have Colleen. Colleen, tell us who you are and where you work and what do you do?
I'm Colleen Bauman, and I'm a partner with Goldblatt Partners, which is a medium-sized boutique firm that has offices in Toronto and Ottawa. I work out of the Ottawa office, and my practice is primarily a union-side labor arbitration practice, along with some employment, human rights, and constitutional law. And in the labor employment world, of course, we frequently are dealing with issues of accommodation in the workplace, and so as part of my practice, I am dealing with clients with access and accommodation needs regularly. And at the outset, I did want to say that my firm is far from perfect when it comes to these issues. Like many of our viewers, there are things on our to-do list and more that we can and should be doing, but we are trying to be both proactive and responsive when it comes to these issues.
And by the way, for those who are looking at their screen wondering, where is Cynthia Peterson? Our fourth presenter was going to be Cynthia Peterson, who's a great lawyer and is also the Discrimination Counsel for the Law Society. Unfortunately, she's really under the weather, so wasn't able to be here, but later on, Colleen is going to give Cynthia's pitch in just a synthesized brief form. So I'm going to now turn to Rob and Joanne and kind of throw it over to you. Tell us about some of the barriers that you folks have found that clients with disabilities can face in getting legal services, and give us, as you go, some action tips on what can be done to effectively address those barriers. Let's start with Rob, and you two can go back and forth till you're all run out.
Sure, thanks, David. I can maybe begin with a couple of quick thoughts, and then Joanne will get into it a little more. So a couple of themes. Colleen had just mentioned, being proactive, and that's so important. There is no end point, right? The whole point of this is that we need to keep on reevaluating, reassessing, and improving, and the ultimate goal is creating a fully inclusive service and a fully inclusive space. So a couple of things to keep in mind before I turn it over to Joanne is probably the first starting point is never make assumptions. And when we think about accommodation and accessibility, we also need to remember that it is very, very individualized. So there are some really quick things that you can do. For example, we talked about signage, having clear signage, ensuring that of course, the built environment has a whole host of issues, as we heard from Thea, but so important in terms of creating inclusive environments. But in terms of our practice, there are some quick things. Before I turn it over, just things such as rescheduling, slotting in a little more time with your client, using clear language, being very careful with the type of language that you use. Those are all very important
Why
things.
is clear language important?
So clear language is important in a number of ways. First of all, I would argue that using clear language is just best practice. I think it's just important, incumbent upon us to really make sure that we use language that's accessible to all of our clients, just not clients with disabilities, but all of our clients. It's also important because we want to make sure that our clients actually understand what information we're sharing, and that we in turn could be confident that we are getting instructions that are based on a very good understanding of that information.
You talked about scheduling more time. Why do you have to schedule more time? What's that all about?
So I think this goes, I do have an example later on that I'll get into, but I think part of that is also knowing your clients. And so you may want to slot in some time. Perhaps there are going to be some times during the day that are better, and sometimes that don't work as well for your client, or sometimes there are good days and bad days. There are going to be, depending on your client and the disability, there are going to be times where perhaps something that would normally take 10 minutes in your practice may take half an hour, and that's okay. So as long as you factor that in and you consider that is part of ultimately the service and the accommodation, then the client will benefit from that. Okay.
Joanne.
Yes, thank you. Just following up with what Robert was saying, what I would suggest, coming from an organization that does primarily referrals, so that means our clients or their family members call us on the phone or send emails. We do not have face-to-face communication. We're not set up as a clinic. So we are basically the pre-screening, pre-assessment for all the lawyers in our community, in a sense, which means that we get to hear really the people in crises. So what Robert was saying about the plain language, when we're doing our intake referrals, it's very important to listen, to ask a lot of questions, to redirect the questions and paraphrase what people are saying to make sure we're understanding what people are saying. When you're talking about the definitions of disabilities, certainly with REACH, given that we have 36 years of work in this organization, we are seeing increases in different areas of disability, particularly the invisible hidden disability that David mentioned. We have people with mental health issues. Sometimes it's concurrent disorders, so there could be a physical impairment, but it also comes with a mental health or anxiety issue. And if people who are calling us are clearly in crises, so we have to consider their information that they're giving to us because they are panicking, they're nervous. It could be a housing issue, employment issue. We have all run of fields of law that are lawyers, and now we have mediators on our panel who provide free mediation. So having said that, it's important that people ask these questions at the upfront. So people in law practices, if you can train all staff, we're talking about reception, people answer the phone, your law students, your paralegals, clerks, to do a very strong intake. And if anybody has practiced mediation, you know that it all starts with a strong, solid intake. The more information you have, the better. Don't ask out front, what is your disability? But ask if any special requirements are necessary.
Okay, let me dive in with both of you on this, because we got some questions on email. What should you ask, and how should you ask it, and when should you ask it?
Well, as I mentioned, David, to start off is to ask if they have any special requirements. So when we're on the phone, we ask people, and we've learned over experience that people may not mention that they can't get into a law office without an elevator. So by asking if there's any special requirements or accommodations needed, we can do the screening. So somebody needs to have an elevator access. The washrooms have to be accessible or nearby. Somebody may want to bring in a service animal to the interview. Others may want to bring a support person, and we're encouraging people more and more to bring in support persons, whether that's a friend, a social worker. It's somebody that will give them.
So the question to ask is essentially at the upfront stage, as a matter of routine, do you have any accessibility or accommodation needs?
Correct.
We'd like to try to meet them.
Correct.
Now, it's okay. Is it okay to put that in writing in any intake form?
So can I
Sure, go.
jump in here?
Yeah.
So a couple of things. Before I get to your question about the form, just to reiterate the importance of just doing this right at the outset.
Yeah.
And again, no diagnosis needed or should one be asked for. But what it also does, not only does it provide you with the information that you actually need to provide the service, and of course, that being said, it's also ongoing, right? Just because you asked the first time, you need to keep on checking in and making sure that that accommodation works. But it also sends a really important signal to the client or prospective client that this is a service and this is a firm that is going to be open and willing to provide the accommodations that clients need. And that is really, really important.
So let me just offer, derive from this, some action tips. Number one, it's worthwhile to pop the question at several points. And number two is build it into your standard documents. So if you've got a letter of retainer or you've got a standard form that you have people fill out when they're seeking your services, to just put in what Jordy talked about before, a statement on an accessibility policy, just a statement saying, our office strives to ensure that people with disabilities, can fully use and benefit from our services. If you have any accessibility or accommodation needs, please let us know as soon as possible so we can do the best to try to address them. If you put that up on your website, if when people phone into your office, you have one of those awful IVR systems, the interactive voice response systems, the press 1, press 2 thing. If in the audio recording of that message, you say the same thing. If your assistant who answers your phone when calls to set up or schedule a meeting in their standard emails, if the signature line for your assistant says the same thing. Those kind of prompts are ways to make sure that people are asked, that they're asked more than once. And as Rob said, it conveys the message that you're providing a welcoming environment for people to ask. The thing that you're going to find, and we talk about this over and over in the 5 webinars that we did on court accessibility, you want to be notified as early as possible about the accommodation need. You don't want to find out on the eve of an important interview that, oh, by the way, they need sign language or some other intervention that you can't just run out and grab on a moment's notice. So let me go back to why don't you two continue where you left off? So we've dealt with the finding, and the other point, if I could just build on this, and both Joanne and Rob were mentioning this, is that you don't need to ask intrusive questions. So, why did you lose your eyesight or whatever? If somebody says they need documents in an alternative format, why they need it really doesn't matter. It's just a matter of saying, okay, which formats work best for you? So asking functionally what they need is usually the way to do it that is the least intrusive and frankly the easiest for you, the lawyer or paralegal. It's the most comfortable. Anyway, carrying on. I've interrupted you. Carry on. Other suggestions you have?
Mm-hmm. On the retainer, sorry, Joanne, or did you want to go ahead? So on the retainer topic, I think the retainer could be a very, very useful tool for a number of reasons. In addition to what David had just mentioned, when we accommodate clients with, for example, support persons who support the client through litigation, we want to be very clear with the role that the support person plays. So always keeping in mind who is your client and who are you actually representing. So the retainer can really clarify those type of roles, can also clarify the accommodations that you're going to provide so that the client is assured that there are going to be certain things along the way that the client will receive. So there are some other ways of using the retainer in a positive way.
I agree. And what I was going to mention is when we talk about the support person and who is the client, it's just, these are just practical best practices as when you're meeting with the clients is to really maintain the eye contact with who your client is and to address your questions to that person as opposed to the support person, whoever that may be. And that goes through the whole process of whether it's litigation or the legal procedure. Speak at eye level. If somebody is sitting in a wheelchair or is in a certain position where they might be in the hospital bed, it's always to address them at their level and to sit down and talk to them face to face. Again, what and Rob had mentioned is the don't presume, don't make assumptions. One of the hidden disabilities that people are not quick in our experience to disclose is illiteracy. There's still a huge amount of percentage of people in Ontario who have literary problems. Dyslexia is one, learning disabilities, but there's people who just never really learned how to read. And in our business of law, a lot of it is word and text and jargon, and it's very important, not just plain language, but don't assume that somebody's running around with a court document that they're able to read it, to even know where to go, what it means. So the plain language is important, but also reading documents to clients, asking them questions. Again, timing is such an important factor. Part of the pro bono work is also to factor in your billable hours. If you're seeing somebody that has intellectual or learning disabilities and needs more time, well, consider that factor in and not bill for the amount taken. One of the biggest complaints our clients have said, since our services provide up to 3 hours of no-cost legal consultation, is that the lawyer threw them out of the office much earlier than they expected. And as legal professionals and paralegals, if we can be more sensitive to the fact that some people need more time in explaining, never mind plain language, but law is a very complex language on its own, that we have to be very conscientious of the words we use and the terms that we very often take for granted.
Let me just jump in and build on this. As well, one thing that will help people as you're listening to this, build on what Rob said about not making assumptions. Two people with an identical disability may use very different ways to be accommodated. Two people may be totally blind. One may use Braille. One may not be able to read Braille at all. One may use a talking computer. Another may not know how to use a computer at all. Some people who have no hearing use sign language, others use captioning, others may read lips. It will vary. So that's why the how can we accommodate you is the best way to go and find out from them. Folks with disabilities are used to guiding people without disabilities on what they need. They welcome being asked. As well, if you want to make sure you've covered things off, it can be helpful to explain, and you can even have this in a standard form thing on your website or on a document you give them to read, or that you say to them if they can't handle print is saying, okay, in dealing with our services, we have to exchange documents and give you things to read. Are there things we could do to assist you in being able to read them? And when we meet, as part of working with us, we may have to meet from time to time. Are there things we could do to make sure that you're able to get to us and get around? Just ask functional questions about the pieces of the activities they need to do with you. Back to you two.
I wanted to talk a little bit about one of Arch's services, which is a free consult to lawyers and paralegals across the province about the accessibility and accommodation issues that they face during their practice. So lawyers and paralegals can call our office and they have an appointment with a lawyer and they can talk through issues around accommodation that arise with their clients.
Is this from lawyers with disabilities or from lawyers
Could be both. So lawyers with or without disabilities that are representing clients with disabilities.
Got it.
As well as lawyers with disabilities who also want to consult with us. And one of the more often than not calls that we get is around capacity and presumption of capacity. So,
you mean capacity to instruct?
To instruct counsel,
right?
So when we think about Rule 3.2 and a client with diminished capacity, there were just a couple of things I just wanted to put out there. One is that we always need to remember that there is a presumption of capacity. And what we hear from clients as well as lawyers who call us is that many times clients feel like they're not getting through the door. So clients with disabilities sometimes feel like they're already assumed to not have capacity based on their disability or based on their speech and language disability, so that there is no real best effort to think about what accommodations need to be put in place so that a lawyer can actually assess whether there is capacity. And to remember, this is a legal determination. It's not a clinical determination. It really is up to the lawyer. So there is a human rights obligation there to make sure that we accommodate our clients before we make that kind of determination. One of the things that is really important is to think about capacity in a very task-specific way, decision-specific way. And what that really means is really figuring out a way to parcel out, for example, the disability and the communication, so not lumping them together. So really thinking about and capacity, right? Not linking the communication with capacity. So that could take on a lot of different forms, and it may very well be that you may want to consult with an expert around communication and language, or it could be as simple as really just spending some time figuring out the best way to communicate, figuring out ways to chunk some of the information, to provide information again in a very clear language way, to identify the best places and times and different ways of communicating that information, to ask the client to repeat back the information. There are many different strategies that can be employed, and what you really want to do is explore all of those strategies before you make any type of determination of that nature.
One thing on the communication I wanted to mention is the talk of the encouragement of bringing in a support person. Some neurological disabilities have speech impediments, and so a person's intellectual capacity is not impeded, but their speech is. And by having a friend, a family member, a support person of any nature attend with a client, that you can then ensure that the communication of the client to the counsel is communicated either through their friend, their companion, and then reiterated back by the lawyer who's taking the information directly to the client to ensure that everybody's understanding, they're on the same page. I think that's important to realize. And again, we talk about timing, but a lot of timing, our clients have asked for more time with clients for a variety of reasons. One, most people are nervous meeting with a professional expert, and especially in an area of law when they're already in a crisis mode, but when people have anxiety disorders, other mental health issues, they need to feel encouraged to continue that communication and to be acknowledged and what they're saying is being understood.
Okay. Anything else, or you got it all?
Sure, I can
ahead.
keep on going
Keep
if
on,
you'd
no,
like,
keep on
David.
going.
So I also wanted to talk a little bit about new and emerging disabilities, and I guess this goes back to the theme about there is no right answer, and it really is about asking your client and asking the individual with a disability. And so we have had a number of cases with clients who have electro-hypersensitivity, and it's a perfect example around, the sort of feeling out, trying things, and maybe some things work and maybe some things don't, but we don't stop. So for example, in those kind of cases, we have a scent-free environment at our office, and so for persons who have multiple chemical sensitivities, we accommodate in that way. But for persons with electro-hypersensitivity, for example, that would not be good enough. So we've had some interesting challenges around how we accommodate, both in terms of just Arch providing the service, but also once we litigate and how the tribunal will accommodate. So there are some clear lessons that flow from that. One is, again, about timing. So with certain disabilities, you never really know when symptoms may be triggered or what may trigger them. So as a lawyer or as a paralegal, you need to sort of be ready for that and factor that in not only in these type of cases, but in various cases, we sometimes go to the client. That could also be in situations around anxiety, for example. Law offices aren't, can be a very stressful place. And so we go to them, or we choose a place that, that is comfortable for the client. So there are those type of strategies. It gets a little more complicated when you're rubbing against other rules, for example, tribunal rules that don't allow hearings to be video conferenced or Skyped. And so in some cases, we have been successful in getting the tribunal to provide those kind of accommodations with the opposing counsel vehemently opposing. But those are the kind of things that really challenge us to be creative. And again, there's no one answer. It really requires ongoing creativity and exploration.
Okay, Joanne, can you give us one more before we go? We're going to go to Colleen after
Yes.
you've got one more to hit us
Thanks.
with.
Yes, my last pitch will be, because we're talking about barriers to justice, particularly with people with disabilities, I don't have to mention that employment, lack thereof, or being underemployed is a challenge for reaching economic equality. So what my pitch is for all the lawyers and paralegals out there in the province is to join REACH. We have a 1-800 number, and although we're only Ottawa, I really feel as a community, as a province, if more lawyers offer their time pro bono to work with people with disabilities, we're a referral source. We'd love your name and email, and we would send them off to your community. So it would take us to network in your community to ensure that people have that access, as they do in Ottawa for the last 36 years. Someone like Colleen, who's speaking next, is on our roster in Ottawa, as are a number of lawyers from her firm. And you know what that is? 36 years ago, there were lawyers had the foresight to anticipate that there's barriers to justice, and particularly people with disabilities, whether it's financial, physical, or anxiety-ridden. Our lawyers are wonderful that we have 160 of them on our panel who are helping people every day with disabilities in Ottawa, and I wish I could share that across the province.
The contact information on how to reach you is on your one-page tip sheet?
Yes,
Okay,
and our
very good.
website is w.reach.ca. Thank you.
All right, great, thank you. So, Colleen, we've now heard about a bunch of things that need to get fixed. Tell us some strategies that you've learned about how a law firm that sitting there looking at this going, oh, heck, where do I start and what do I do? What's your answer?
Well, I think, as you've heard, Jordy's already spoken to this, but where we started and where a good place to start is looking at your barriers to your offices and services. And again, this is not a one-time thing. This is an ongoing thing. You use the feedback that you get from clients to feed into your identification of barriers, and you continually reassess that. And then from the plan, I think you also have to look at your accessibility plan as a living document.
What do you mean by accessibility plan? Tell us more about what that is.
So under the ODA, your organizations are to have an accessibility plan that identifies the steps they are taking in order to reduce barriers and to increase accessibility. And I think it's important to be revising and amending that plan as barriers are removed and new barriers are identified, and also to revisit and revise that plan at times of renovation or moves. Our Toronto office has just recently completed or is in the midst of actually completing a renovation, and that's of course a time to be proactive about accommodation measures. One example, this is more of a accommodation for employees than clients, but we were finding increasing numbers of requests from staff for sit-stand desks, for example, as an accommodation measure. And so when new desks were installed at workstations, everyone was provided with sit-stand desks as an example. I think that's an example of trying to be proactive on the accommodation front. And then on the training front, again, we're trying to be proactive by providing training at regular intervals, and both looking at this from...
Is that to lawyers and staff?
That's to lawyers and staff, correct. And looking at this both from the practical front, for example, Jordy spoke to the training about guidelines for use of respectful and appropriate terminology, guidelines for interacting with individuals with service animals, a whole host, of practical advice for increasing accessibility. At the same time, we're also trying to be proactive about systemic issues. We're just about to start training all our staff and lawyers about overcoming an unconscious bias, for example. So trying to address more systemic, getting to attitudes and bias as well.
Okay, well, that's great. And what I'd also like to ask you, if you might be able to do for us, is be Cynthia Peterson for a minute and tell us what she was aiming to say.
So, Cynthia is a partner in the Toronto office of my firm, so I was able to speak with her before today, and she apologizes for not being able to be here. And Cynthia also has a role as Discrimination and Harassment Counsel for the Law Society. And clients with disabilities who encounter accessibility issues can contact the Disability and Harassment Council free of charge. This is a service that's funded by the Law Society. And then the Disability and Harassment Council will work with the parties, and the client and the lawyer, in developing communications protocols, accommodation plans, etc., to remove accessibility barriers and resolve the client's concerns. Now, this process is completely unrelated to the Law Society's discipline process. And while it is complaint-driven in the sense that the client needs to call or email the Disability and Harassment Council to initiate a complaint, the focus is really on resolutions. The service is also completely confidential. Discrimination and Harassment Council shares anonymous statistical data with the Law Society about the volume and nature of calls and contacts that the office receives, but they don't share any identifying information. Cynthia has indicated that the most common type of complaint that she receives in her role as Discrimination and Harassment Counsel is about lawyers who don't accept and take seriously that their client has a disability that requires accommodation.
That's the biggest, not the biggest disability complaint, that's the biggest complaint.
That's the biggest complaint that she in her role receives.
Right.
Yeah. So, for example, a client with an anxiety disorder who requires more time to make decisions, yet the lawyer dismisses dismissive of that concern or tells the client that, litigation is stressful and to deal with it. Or a client with cognitive issues who requests information in writing and able to process it, or requests information in advance of a meeting to be able to prepare, yet the lawyer resists providing it. So in these type of situations, if requested by the client, Cynthia will work with the parties to often develop a communication protocol about how and when information will be provided, about the time that will be built into the schedule, etc. And it's often about taking the client's needs more seriously and making sure that you are listening to what is the client's preferred method of communication and trying different approaches with respect to communication, with respect to information that's being provided. In contrast to these types of concerns, she does not have as many complaints about physical barriers. So it's much more about the communications and interactions with lawyers that she hears about. And I would just note that that Cynthia has provided a page in the material that has resources and web links with more information about the Discrimination and Harassment Counsel that you can access.
All right, well, we're now at the point where, thank you very much. We're now at the point where Rob's going to grab the iPad and let us know about what questions have come in from you, our audience, and we'll see if we can handle a couple of those. What do you got?
I have many really good questions, so thank you everyone for questions. There are many of them. There are a couple of themes. One of them perhaps is a good start, which is the relationship between the AODA, the Human Rights Code, and the Law Society rules. And I know you touched on it, but perhaps it warrants a little bit more exploration.
Let me take first run at this so that people should understand a common mistake that is made by the government and in the private sector is to think if you've done what the AODA regs require, you've done everything you got to do. And sadly, having led the disability community's negotiation of what those regs would include, we tried to get them to live up to human rights standards. They typically don't. So that, for example, if they give you any number of years to make your websites accessible, you would not be able to justify those long delays as necessary, that doing any better would be an undue hardship, that continuing to make inaccessible web content up to then is perfectly justified no matter what. So the Human Rights Code, the Charter of Rights prevail. The Code of Professional Conduct essentially embodies a human rights standard. Doing what the AODA standards require is always good to do, but you should always have an eye on, are we achieving the result of legal services which are fully accessible? And if we haven't, we got to think about what more we should do. So the most important thing to avoid doing is thinking that, oh, heck, I've done what the customer service standard says. That's all I got to do. Okay, what other, anything you folks want to add, or does that sort of cover it?
I think you covered that beautifully.
All right, thanks. So what else have we got? What other common questions?
Some other themes. One is around some particular accommodations. So one in particular around hearing disabilities. Somebody wanted to know, or a couple of people wanted to know, the difference between deaf interpreters and American Sign Language interpretation or Quebec Sign Language interpretation. I think that's a really good question. I think a lot of people perhaps would benefit from some clarification. Okay,
I'm happy to pitch it to you if you can handle it, but I also encourage folks to watch one of our earlier 5 webinars on court accessibility. Has an entire, about a 20 or 30-minute panel on different accommodations, communication supports for people with hearing loss that goes into this in some detail. So can you give us a quick snapshot on this?
Sure, I can. So one of the first things that everyone should know is that when you are communicating with someone through an ASL interpreter, you're losing a lot of information. So what deaf interpreters do is that they are essentially part of the interpreting team. So there will be a person who is communicating via sign language, and that will get communicated through the the deaf interpreter through the ASL interpreter and so on, and that's sort of the cycle. So what the deaf interpreter is doing is adding some of the cultural pieces or some of the other pieces that a hearing interpreter interpreting ASL may not capture. So it's attempting to augment the accuracy of the interpretation. Again, back to the point that we can't make assumptions that everyone who is deaf would prefer that. In some situations, that's not the case, and in some it is. So again, very important to really check in with the individual who requires the interpretation to figure out what would be most appropriate for that person.
All right, let's take one more question if we can, or one more bunching of questions.
Sure. So there are some around the use of support persons and how that impacts the solicitor-client relationship and issues around confidentiality and how that's dealt with.
How do you deal with that at Arch? I come in, I've got a support person, I start making all sorts of disclosures to you, the lawyer, that if I was in the room alone with you would be privileged. But now we've got my support person sitting there. What exposure do we have that somebody might subpoena them, that what I say in your presence is not privileged in their hands?
Mm-hmm. And that's really tricky. And so our starting point is not to have a support person in there. So the starting point is whenever possible, we meet with the client. We meet with the client alone. When we include support people, we don't just include them in all aspects of the case. So if we are representing someone and we have already made the determination that they have capacity, we're very careful with what is shared. There are, sorry.
So I was going to say, because Joanne, you talked about the importance of having support people. Would you have them in for kind of the general information but not the touchy stuff? Is that how you would, the sensitive stuff? Is that how you would do it?
Well, our services are the original meeting, the first intake meeting. So this is good instructions for the lawyers that see our clients afterwards, because we're sending them for a consult and they usually like to have somebody with them. After that, I guess, given what Robert is saying, it's up to the lawyer's discretion how they're going to proceed. Many of our clients just want a consultation. Do I have a legal case or not? If it's litigation, I guess then you have to be wary of the issues of confidentiality.
But the strategy would be to try to figure out how to have the support person present for maybe some of the general information that doesn't involve disclosing things that the client would need privileged.
Exactly.
And then have the support person step out, and if they're needed for a break or whatever, they're still available
exactly.
as needed. Okay.
And when I just want to mention the issue about very high anxious people, some of the feedback we get from both the legal profession and the clients is that sometimes they don't even show up to that meeting that we've set them up. So we've set up a meeting and they don't go because if they thought they only went alone, as we alluded to before, just going to a law firm is very intimidating. So by having that support person at that first meeting is important. And then, as you said, you can carry on from there whether the proceedings go ahead or not, and whether the support person continues through the whole process.
Okay, I think we could actually squeeze in one more question. Rob, can you pull one more for us?
So a couple of questions I'm seeing just about, and maybe this is a nice way to end, just generally the kind of things that we can put in place to make clients feel more comfortable in giving instruction. So it kind of feeds to what you were just saying. Yes. Perhaps if there's any last kind of remarks that we can make.
So let's get all three of you in on this. Colleen, can you help us with this? I mean, you've got clients you're dealing with who've got conflictual situations and labor situations. A lot of them have disabilities and they're disability related. Putting them at ease so that you're able to deal with it.
I think we've already touched on a number of possible ways of doing this, including making sure that you found out from the client what their accessibility requirements are, accommodation needs are, that you are using plain language, that you are making sure that your client has enough time to process information, to ask questions, that you're using your client's preferred method of communication, be that email or written materials. So I think checking in with your client at regular intervals, I think those are all good ways of ensuring that your client is feeling comfortable. I also wanted to just note, this is one thing I did want to touch on, is that I think you can't just think about that meeting in your office space, but you also have to remember that you're going to be going with your client into other environments. And often you have a lot of control over your own meeting space and your own office environment, but it's when you go into mediations, when you go into arbitrations, negotiations, where you are dealing with adversarial counsel, where you might be dealing with mediators, where that can bring its own host of issues. And again, that might take arrangements being put in place in advance. I know that in labor arbitration practice, we're often in a mediation environment, and there is this pressure that you're going to get a deal by the end of the day. For many individuals with either cognitive impairments or with anxiety, that is not something that is possible for them to be able to make decisions in that type of environment. And so it may be that you might have to tell opposing counsel ahead of time that your client is very interested in settlement, but they're going to need a day or two after a mediation in order to be able to come to a decision, and that's going to be part of the deal going into this mediation. So I think you have to be creative, you have to be proactive, and work with your client to make sure that you understand what their needs are.
All right, well, I want to thank you very much. I'm going to thank our panel, and I'm going to spend the last 11 minutes just doing a wrap-up with some final action tips for everybody. I want to thank you all. This is fabulous. On the very subject that you were just talking about, Colleen, I sound like a broken record, but the earlier 5 webinars on aiding people with disabilities to fully participate in the court process have tons of action tips on exactly what you were just talking about. And as well, as we record this in April of 2017, my colleague at Osgood, Professor Martha Simmons, who's leading professor there on dispute resolution, she and I are soon going to be coming out with a handbook for mediators on accommodating people with disabilities in the mediation process that all might find somewhat helpful once we get it done, which it almost is. So let me wrap up with a bunch of practical tips. So you've watched us talking here for an hour and 3/4. I'm hoping as you watch that you've come to see that there's a lot of need out there, and there's a lot of people who would benefit from action. What do? I don't want you to feel overwhelmed. I don't want you to freeze because you think there's so much to do, there's nowhere to start, and so on. I'm going to give you some very practical things that you could think about starting on like tomorrow morning. The first thing to do is to understand that this is not an all or nothing operation. If you could take some immediate action to remove some barriers, you're making progress. Every new barrier or every additional barrier remove or prevent is going to make your legal services that much more accessible. So while it'll be great to get to the point of complete accessibility, think right now about just making progress. And that in turn leads me to my next suggestion, which is you don't solve this without a plan. So it's worthwhile for your office, your firm, to decide you're going to do an accessibility plan, not just what the legislation or the regulation requires, but an operational plan. How do you do that? I encourage you to consider setting up a disability, accessibility, and accommodation committee. Get them together and say, let's do the following things. Number one, let's do a quick barrier audit. Let's just figure out, just off the top of our heads, I don't mean a multi-year with consultants and all that stuff. I mean like just sit around and canvass the members of your firm, ask some of your clients, and in short order, you'll come up with a list of things that need to be done. Now, there may be areas where you're going to want to engage specialists. We'll get there in a minute. But get a list of what the barriers are. Then divide them into 2 categories. The one where fixes are readily achievable, getting that temporary ramp for the one step at the front door, or moving the planter out of the path of travel, that kind of stuff. changing your retainer forms to ask the right question, to solicit requests for invitation, changing that voice announcement when people phone in and hear the voice just saying, hey, we'd like to accommodate, here's how to do it, and so on. And the other list is the stuff that will take more effort. And then develop a step-by-step. And even if you haven't decided on the long-term stuff, you can at least parcel out the short-term stuff. It may be a matter of simply contacting your web designer and saying, hey, do you know accessible design? Is our site accessible? If not, are you prepared to deal with its accessibility needs? We don't want anything going up from now on that is inaccessible, starting today. And if they don't know how to do it, you might want to find a better web designer who does. Those kind of steps are things that you can take right away. If you want a list of really readily achievable things, one of the resources we've provided online initially doesn't look like it's for you, but you can use it. My coalition, the AODA Alliance, along with Arch Disability Law Center, one of Rob's fabulous lawyers, Diane Wintermute, we collaborated and we filed a brief with the government on things that we wanted the customer service standard to be amended to include. They were all readily achievable things. Go through it, steal our ideas. If you don't have an accessible bathroom and you don't know whether you can quickly get an accessible bathroom, being able to tell clients and others where the nearest accessible bathroom is a useful bit of information that's not hard to find and costs nothing to share or post or make available. Similarly, the braille and raised line and symbol sign on the bathroom doors, if I leave a legacy, may that be it. That would be something that is not a big deal to do, but it's a good thing to do. Those kinds of things are things you can, and celebrate your successes. If after 6 months you can say, hey, tick off, we've found and fixed 6 barriers, we're better than we used to be. And you can make progress from there. Let me offer you one final action tip, and it's in the one-pager that is my contribution to the package of one-pagers that I invite you to download and bring to your accessibility committee as a source for ideas and advice. A really useful thing to do that will cost you absolutely zero and that you can start up really quickly is to designate one person among your staff, among your lawyers or your office staff or a team of 2 as your accessibility and accommodation point people. They're the people who in the firm you could ask to learn as much as they can about this, offer tips around the firm, and they can be the go-to-it person if you got a problem. They could be the go-to-it person if feedback comes in about barriers. They're the ones who could be on top of what's going on and can be your instant resource. I'm not talking about a new hire. I'm talking about an existing point person. To its credit, the Ontario government established exactly that, an accessibility and accommodation point person in every major court facility. And they're the ones that you can go to when you come into court if you need an accessibility problem addressed. And they are also a wonderful resource within the government to be able to go to them and say, hey, what are the complaints we're receiving? What's the biggest #1 thing we got to fix the soonest? And just from their day-to-day collection of feedback, that really helps. The final thing that this accessibility point person in your firm can do is they can become your kind of watchdog champion. So the firm is thinking of organizing some kind of event for clients, some kind of event to invite people to. They're the ones who will be at the table going, hey, where we're going, is it an accessible choice? If not, maybe we should rent another place. Doesn't cost anything to have somebody there within your staff who's going to be your lead person on it, who's acquiring some expertise. You'll find my one-pager for you is a memo you could send within your firm making this very recommendation. So, just a couple of other closing things. We've been talking about accessible client services, but everything we've talked about pretty much will also help you ensure that your workplace is a workplace where people with disabilities can fully participate. Whether the bathroom has an accessible signage will be benefit, or that they will have accessible signage will be beneficial for your clients who need that signage and for your employees and colleagues who need that signage. Should you later need that signage because of change in your eyesight, you will welcome it too. So think of this as a win-win. You solve two problems with a single strategy. We are currently, I regret to say, in Ontario, well behind the US in the area of accessibility. Not that they're perfect, but having just come back from two different conferences down there on disability issues, when I travel across the border, I really feel like I'm going through a time machine in terms of disability accessibility. Canadians are usually surprised at that because they think that we're ahead on this sort of whole bandwidth of things, but when it comes to this, we're not. The American Bar Association itself has a number of strategies and initiatives in this area. I encourage you to encourage our Law Society to do more of the events like this if you think it would help you. I commend the Law Society for sponsoring this. A huge thank you to the wonderful staff at the Law Society who pulled this event together and who are always available to make these events succeed. We wouldn't have been able to do it without them. I want to encourage you finally to follow on the resource, or use the resources, not only the ones that we've been providing you with, these one-pagers, but going on Twitter, going on social media. There's a ton of stuff available. And if you come up with your own, tweet about it as well, because we'd like to know about it and we'd like to share it around too. So thank you all very much for tuning in. Let us know by your feedback if you think it would be useful to cover more of this and what topics you'd like us to address. So signing off from the World Headquarters of the Law Society, my name is David Lepofsky. Thank you very much.